Okay, let's dive into this. Think about this. A major international drug plot hatched by some, well, seemingly respectable people. But here's the kicker. It was infiltrated by a mole almost from the very beginning.
Sounds like something out of a movie, doesn't it?
It really does. But what if that sting operation, doesn't quite stick to the script? What if the police aren't just watching, but maybe, just maybe, pushing things along a bit?
And then what happens when it all falls apart? Not just the bust, but the years and years of legal battles that follow. High-stakes stuff that really tested the system.
Exactly. This isn't fiction. We're talking about Operation Opaline, a really complex Australian case, R.V. Reardon, Michaels and Taylor. It went through the courts, challenged rules on evidence, disclosure, appeals, the works.
And it holds some incredibly important, maybe even quite stark lessons for lawyers, particularly for young barristers just starting out. Things you really need to know.
For sure. So that's our mission today in this deep dive. We want to walk you through this whole saga, the plot, the undercover sting, the trial drama, the appeals, all those procedural twists. We'll look at the characters, the surprises.
And really focus on what this case teaches us about the challenges, the responsibilities, the ethics of standing up in court.
And we're basing all this on the actual case materials. We've got the court judgments, the NSW Court of Criminal Appeal decisions from 2002 and 2004.
Yep, 2002 NSWCCA 203 and 2004 NSWCCA 197. Plus, a really helpful case summary document, Operation Opaline, The Reardon Conspiracy, a true crime legal thriller.pdf. So it's all grounded in the sources.
Okay, let's set the scene. Who are the key players in this scheme?
Well, at the center, the organizer, was Michael Leonard Reardon. The documents describe him pretty clearly as a principal, the organizer. He was the main guy.
The architect. And he needed a way to make it happen, right? A cover.
Exactly. And he brought in Ian Cox. Cox was an Australian wine importer. His legitimate business, you see, provided that perfect cover. The plan was to smuggle 50 kilograms of cocaine, a huge amount from Chile, hidden within his wine shipments.
Clever, in a way. Devious. But Cox wasn't tried with the main group, was he?
No, the sources mention he was dealt with separately later on. We're focusing on Reardon, Michaels, and Taylor for the main trial.
Okay, so who else was involved? Taylor?
Right, Clifford Barry Taylor. He was another co-defendant, but described as having lesser involvement. He was in his early 50s at the time. Seems he got pulled in through acquaintances. A guy named Alan Johnstone was mentioned.
The classic lure. Easy money.
That's what the description suggests, yeah. Drawn in by talk of easy money. Later on, he apparently claimed ill health during the proceedings, maybe trying to lessen his culpability.
Now, 50 kilos from Chile. They needed someone on the ground there, didn't they?
Absolutely. Enter Douglas Crombie. He's a really pivotal figure, described as a accomplice turned witness. So initially part of the plot, then he flipped.
Flipped. That always raises red flags, doesn't it? Reliability issues.
Huge issues. Taylor actually recruited Crombie at first, tasked him with finding a supplier over in Chile. Crombie became absolutely essential for the prosecution's case later, but as you say, his evidence was always going to be scrutinized because he was an accomplice looking for a deal. Potential motive to lie, right?
Definitely. So did Crombie find the connection?
He did. He got in touch with Lily Villegas. She's simply noted as the Chilean connection. She reportedly agreed to source the cocaine for them in Santiago, so she was the link on the supply side.
Okay, plan, cover, connections. What about the money? 50 kilos isn't cheap.
No kidding. They needed significant capital.
Yeah.
This is where Alan Dillon comes in. He acted as a go-between. He knew Reardon, and he knew someone he thought could finance the whole operation.
And this is where the story takes that major turn. Dillon introduced Reardon to
W, just W, described as the mysterious financier. So Reardon thinks, great, I found my investor. He thinks W is going to bankroll this massive drug import.
But W wasn't who he seemed.
Not at all. This is the core of the sting. W was secretly a registered informant for the New South Wales Crime Commission. He was playing the role of investor, but feeding everything straight back to the authorities. He was the mole inside the conspiracy from very early on.
Wow. So the moment Reardon pitched the idea to W.
Game on for law enforcement. The NSW Crime Commission was immediately looped in. And this wasn't just sitting back and watching. It triggered a full-blown investigation.
And other agencies got involved.
Oh, yeah. The National Crime Authority, the NCA, and the Australian Federal Police, the AFP, they teamed up. And crucially, they brought in their Chilean counterparts. This became Operation Opaline. a proper international joint task force.
Who was running it on the Australian side?
An AFP officer named Michael Purchase, who was actually seconded to the NCA at the time. He was supervising the operation.
And W's role shifted then. He wasn't just listening.
No, he became much more active. To Reardon, he's the money man, right? Providing the cash, pushing the deal forward. But for the police, he's gathering intelligence, maybe even acting as an agent provocateur, though the courts later saw it more as facilitating pre-existing intent. He's providing the bait, essentially, while guiding the investigation.
So surveillance must have ramped up significantly.
Hugely. Warrants were obtained for phone taps, listening devices. They needed hard evidence. The sources pinpoint one specific meeting, June 11th, at a pub Reardon and AU recorded start to finish, captured every incriminating word. That tape became gold for the prosecution.
And things moved to Chile.
Yes, the focus shifted internationally. This brings in another key undercover figure, Oscar. He was a Chilean police officer working undercover with that codename.
What was Oscar's job?
He posed as an intermediary in Chile. He dealt directly with Reardon when Reardon traveled there. His mission was twofold: gain Reardon's trust, but then strategically apply pressure. Force Reardon to commit, reveal his suppliers, show the drugs, catch him red-handed, basically.
So real coordination was needed between Australia and Chile.
Absolutely critical. Comisario Antonio Cubillos, a Chilean narcotics chief, was the main point of contact, liaising with the Australians, giving phone updates on what Reardon was doing in Santiago.
But Reardon's behavior started to raise eyebrows in Chile.
It did. The Chilean surveillance teams found him odd. He seemed unnervingly confident navigating Santiago using public transport, didn't seem to need directions, which seems strange for someone supposedly setting up a complex drug deal in a foreign city for the first time.
And he wasn't meeting local criminals.
That was the really weird part, according to the logs, the running sheets. He seemed to be actively avoiding contact with the usual underworld figures you'd expect him to be dealing with to source 50 kilos of cocaine. The Chileans found it disconcerting. They started to wonder what his real game was.
Which led to this rip-off theory.
Exactly. Comisario Cubillos shared this insight with the Australians around early August 1997. He suggested maybe Reardon isn't actually planning to buy drugs. Maybe he's just going to take the money, W's money, which was really police money, and disappear.
Yeah.
Double-cross everyone.
The police and maybe even the suppliers.
Potentially both. This rip-off theory, the idea that Reardon was faking the drug deal to scam the financier, got recorded in those detailed Operation Opaline running sheets. And ironically, years later, that became Reardon's actual defense at trial.
So how did the police react to this possibility? That their main target might just steal or buy money?
They decided they had to force his hand. Cubillos and the NCA agreed. Start pressuring Reardon. They needed him to commit to the drug part of the deal, not just talk about it.
Pressure from both ends.
Yes. Oscar in Chile was instructed to apply heavy pressure. Try and get Reardon to actually contact his local source in Oscar's presence, so Oscar could physically sight the gear, see the cocaine. Meanwhile, W, back in Australia, codenamed CC-463 in the logs, would keep calling, pushing, saying, the money's ready, let's get this done.
And then Reardon asked about a gun.
Yeah, another startling detail that emerged. While in Chile, he inquired about getting a gun. For the authorities, this seemed to fit perfectly with the rip-off theory. If you're planning to betray dangerous people, you might want protection.
Raise the stakes considerably. Fear of violence.
Definitely. The sources mentioned police and even a Chilean magistrate worried things could go south. A real concern it could turn violent if he was planning a double cross.
But Reardon kept going, despite the pressure and surveillance.
Apparently so. The plan continued. A large sum, USD $375,000, likely the police buy money funneled via W, was transferred into an undercover account to show the funds were available.
To show Oscar the money was real.
Right. Once that money was visible, Oscar and his team really dialed up the pressure for delivery. The noose was tightening.
How many trips to Chile were involved? Sounds like a lot of back and forth.
The sources mentioned specific trips in July and October 1997. Reardon went, Cox went, Crombie went too. Crombie had this weird code name, Jungle Bunny, or JB.
Jungle Bunny? Seriously?
Yep, according to the logs. On one trip, Crombie even brought his Spanish-speaking sister-in-law, Haiti Martinez-Diaz, presumably to help with communication. They met Oscar.
But still no drugs actually purchased.
No. Despite these trips, despite the money shown that $375,000 was put in a safety deposit box in Chile to prove the finance was, their no deal was finalized. W, back in Australia, was footing the bill for the flights and expenses, facilitating all this travel.
So what happened after that first trip fizzled out?
Reardon came back to Australia, kept meeting W, kept talking like the deal was progressing. Meanwhile, Crombie and Martinez-Diaz weren't happy with the lack of progress. Martinez-Diaz went back home. And then, surprisingly, Lily Villegas, the original Chilean connection, she actually flew from Australia to Santiago to try and push things forward from that end.
Some more meetings.
Yeah, meetings between Reardon, Crombie, Villegas, someone called Pedro is mentioned. Villegas and Crombie also met with other potential suppliers. It sounds like a scramble to make the deal happen, but it just didn't.
And eventually the police decided enough was enough.
Seems so. By early 1999, despite all the effort, the pressure, the travel, no cocaine ever made it to Australia. The operation wrapped up and the focus shifted. Reardon, Michaels, and Taylor were arrested and charged. Cox, as we said, dealt with separately. The evidence wasn't seized drugs, it was the mountain of recordings, the logs, and the testimony of insiders like Crombie and W.
Which sets the stage for a pretty intense trial.
Absolutely. The trial of R.V. Reardon, Michaels, and Taylor kicked off in the NSW District Court in the spring of '99, described as a high-drama courtroom thriller.
And they all pleaded not guilty.
They did. March 22nd, 1999, arraigned together. All pleaded not guilty to conspiracy to import a commercial quantity of cocaine. Huge stakes.
The Crown laid out the whole story we've just discussed.
Pretty much. The initial pact with Cox, getting Crombie and Lily involved, the approach to W, the whole international sting. Their evidence was massive. Hundreds of calls, recordings, logs, plus the insider witnesses.
Let's just quickly note the legal team's at trial again. Judge Ainsley Wallace presiding.
Right. Crown prosecutor instructed by the Commonwealth DPP for the defense. Reardon had Mr. M. Ramage QC Lidding, instructed by D.J. Humphreys from Legal Aid. Michaels had Mr. S. Corish, instructed by Mark Cleese and Associates. And Taylor had Mr. P. Byrne, SC, instructed by Horowitz and Belinsky. And a Mr. Watson argued against one application. Serious firepower on the defense side, with Queen's Counsel and Senior Counsel involved.
So Crombie was a key witness for the Crown. The accomplice turned witness.
Absolutely central. He testified about the planning meetings, the conversations, pricing, logistics, his dealings with Reardon and Taylor. Incriminating stuff.
But with that huge credibility issue hanging over him, the motive to lie for a lighter sentence.
Exactly, which is why the judge had to give that strong warning under Section 165 of the Evidence Act. That's the rule for unreliable evidence. The judge basically told the jury, be very careful with Crombie's testimony. He's an accomplice. He might have reasons to make things up. Don't just accept it without careful thought.
And then Crombie went a bit off script during his testimony.
He did. He started saying things that didn't quite match up with statements he'd given police earlier. This put the Crown prosecutor in a tricky spot. What do you do when your own witness starts changing their story on the stand?
Section 38 time.
Bingo. Section 38 of the Evidence Act. It allows a lawyer, with the judge's permission, to cross-examine their own witness if that witness gives unfavorable evidence or evidence inconsistent with a prior statement.
So the Crown asked to cross-examine Crombie.
They did. They argued his testimony on things like airfares and specific discussions about the importation was unfavorable or inconsistent. Defense counsel Mr. Watson objected, saying the Crown should have handled it differently, but the judge granted leave.
Why did the judge allow it?
Judge Ainsley Wallace felt it was necessary to give the jury the full picture. She balanced it under S.192 fairness, avoiding delay. She figured allowing the cross-examination would highlight the inconsistencies, which could actually help the defense by showing Crombie was unreliable. But it also allowed the Crown to put Crombie's prior, possibly more damaging statements before the jury. It was a tactical move.
And the appeal court later said this was okay, even good practice.
They did. They saw it as ethical advocacy. The prosecutor wasn't hiding the inconsistencies. They were bringing them out into the open using the proper legal tool. It showed candor, even though it's the unconventional site of cross-examining your own witness. A real lesson there for barristers.
Okay, what about the other key witness, W, the informant?
His evidence was powerful because, unlike Crombie's potentially shifting memory, W's interactions were mostly on tape. Hard to argue with recordings of Reardon planning the deal.
But his credibility was still attacked.
Oh, absolutely. The defense went hard on him. He was an informant, involved in deception. Plus, he received benefits for cooperating leniency on other charges. The defense argued he had every reason to embellish things to please the police.
Was there a specific point of conflict about W's evidence?
Yes, a crucial one. Reardon claimed there was an earlier unrecorded meeting where W first suggested the drug deal. W denied this completely, saying the recorded June 11th meeting was the first time drugs were mentioned. This was vital for Reardon's defense, who really started this. Was it Reardon or was it the police informant pushing it?
And then there was that tape incident, something played by accident.
Right. A bit of courtroom trauma. An unedited version of a tape was accidentally played for a moment instead of the properly edited one.
What was on the unedited bit?
References to other alleged crimes by Reardon stuff like false licenses, getting passports for wanted people, marijuana, other drug matters. And worryingly, a vague suggestion of potential violence.
Defense must have jumped on that. Asked for the jury to be discharged.
Immediately. Reardon's counsel argued it was highly prejudicial bad character evidence, especially the violence hint, totally unrelated to the charge, and risked poisoning the jury's mind. They wanted a mistrial.
But the judge refused.
She did. She considered it carefully. She pointed out some other criminal activity was already alluded to in the admitted tapes. She felt the violence reference was indistinct, maybe not even decipherable by the jury. And critically, the wrong tape was stopped immediately, and the jury never got to take it into deliberations. She decided it wasn't enough to derail the whole 6-week trial.
Okay, so what were the specific defenses run by the accused?
Reardon, as we anticipated, ran the rip-off defense. He basically said, yes, I had those conversations. They sound bad, but it was all an act. I was just pretending, trying to con W out of the money. I never actually intended to import any drugs.
So the jury had to decide. Genuine plot or elaborate scam?
Exactly. Was he really planning importation, Crown's case, or was it a ruse, Reardon's defense? Michaels acknowledged some involvement, but claimed it was minor, conditional on Reardon needing him. He specifically denied arranging the supply in Chile, which was the Crown's main allegation against him.
And Taylor?
Taylor argued lesser involvement. He said, yes, he introduced Crombie to Reardon, but he claimed he wasn't part of, or didn't hear, the actual conversations about importing cocaine, trying to distance himself.
How long did the jury take?
After about 6 weeks of trial, they deliberated. Around May 11th, 1999, they came back.
Guilty.
Guilty. All three, Reardon, Michaels, Taylor, on all counts. The defenses failed.
The jury just didn't buy Reardon's ripoff story.
Clearly not. The sheer weight of the recorded evidence, his detailed planning, it just seemed too elaborate to be a simple scam. An appeal judge later called the level of coincidence required for his story to be true extraordinary. The jury found no reasonable possibility his version was correct.
The sentencing followed. Must have been heavy.
It's very heavy. June 22nd, 1999. Judge Ainsley Wallace delivered the sentences. Reardon, as the principal organizer, got 17 years, 11 months, with a 14-year non-parole period, near the maximum.
Did his personal circumstances help? Disabled wife and child?
Considered, yes, but the judge found they weren't enough to significantly reduce the sentence given the scale and seriousness of the planned importation. Michaels got even longer 20 years, with 16 non-parole, based on his perceived role in supply and his prior history.
And Taylor?
Taylor got 12 years, with 10 non-parole, reflecting his lesser involvement.
Why so severe overall? Just the quantity?
Quantity was huge, yes, 50 kilos, but also the international sophistication, the planning involved, and denunciation, the court sending a message about this kind of crime.
Did it matter that no drugs actually got imported?
The Crown successfully argued, no, it didn't mitigate the conspiracy. The crime was the agreement and the intent to import for profit, which the jury found proven. Allowing the operation to continue, the Crown argued, helped identify more players like Michaels and others, Arturo, Pedro. The sentences reflected the full intended scope.
So, guilty verdicts, long sentences, end of story.
Not quite. In these big cases, it rarely is. All three launched appeals against their convictions and their sentences. So began the next phase, heading up to the NSW Court of Criminal Appeal.
And this is where those running sheets become really important again.
Exactly, particularly for Edgar Michaels. Leading up to the appeal hearing, he was apparently moving heaven and earth trying to get hold of those internal police logs from Operation Opaline, the renegades. He believed they contained crucial information withheld at trial.
Hadn't the defense tried to get them before trial?
They had, via subpoena to the NCA, but the NCA resisted, claiming public interest immunity PII.
PII. That's the argument that disclosing sensitive info hurts the public interest more than it helps the defense.
That's the one. National security, informant safety, police methods, that sort of thing. The NCA also argued the defense hadn't shown a legitimate forensic purpose, a proper legal reason why they needed these specific internal documents for their defense. That initial fight over the subpoena wasn't fully resolved before the trial started.
But Michaels kept pushing after conviction.
Relentlessly. He used Freedom of Information requests, went to the Administrative Appeals Tribunal, separate processes trying to force disclosure of these documents.
So when the appeal hearing date arrived,
October 25th, 2001, the morning it's listed before the Court of Criminal Appeal, Michael's barrister, Mr. Korish, stands up and asks for an adjournment. He argues it's unfair to proceed while this potentially vital evidence, the running sheets, is still tied up in these FOI and AT processes.
did Reardon's team join in asking for the delay?
No, interestingly, Mr. Ramage QC for Reardon didn't join that application. The judgment specifically notes there was no evidence that Reardon had taken similar steps to pursue the documents like Michael's had. Maybe they felt their existing appeal grounds were stronger, or they just hadn't focused on the running sheets yet.
Who were the judges and lawyers for this first appeal? R.V. Reardon, 2002.
The bench was Hodgson J.A., Simpson J., and Barr J. for the Crown, Mr. P. Roberts, S.C., instructed by the Commonwealth DPP, and Mr. Johnson appeared for the NCA, specifically on the PII issue. For the defense teams, largely the same as trial. Ramage QC for Reardon, instructed by Legal Aid, Cordish for Michaels, Mark Cleese and Associates, and Byrne, S.C., for Taylor, Horowitz, and Belinsky. Consistency there.
How did the court handle the adjournment request?
They didn't want to delay the whole thing indefinitely, but they recognized Michaels might get something useful. So, a compromise. No full adjournment. Reardon and Taylor's appeals would proceed that day. But Michaels was given leave to file more evidence and submissions later if his FOI 8 efforts yielded anything significant, so his appeal was sort of split in two.
And did Michaels get anything significant?
He absolutely did. Enough that the appeal judges scheduled special follow-up hearings in March and April 2002 just to deal with this new material. The running sheets were front and center.
What was Michaels arguing based on the sheets?
His argument focused on that police pressure aspect. The logs show the deliberate strategy to pressure Reardon. Michaels argued this could support an abusive process claim or something close to entrapment, that the police conduct was so improper it tainted the conviction. Maybe, if known at trial, it could have led to a stay of proceedings.
And Reardon got involved at this stage too.
Yes. By the April 5th hearing, Reardon's team had seen the running sheet excerpts disclosed to Michaels. Even though they hadn't pushed for them earlier, the court allowed Mr. Ramage QC to make arguments for Reardon based on this new material.
What was Reardon's argument about the sheets? Different from Michaels.
Similar on the police pressure point, relevant to fairness. But crucially, Reardon's team focused on the entries where police themselves suspected Reardon may have been engaged in a ripoff.
The direct corroboration of his defense.
Exactly. For the defense, this was huge. Internal police documents aligning with the accused's story. And they weren't disclosed. It goes right to the Crown's duty of disclosure. They argued this material could have fundamentally changed the trial dynamic.
How did the Crown respond to these arguments?
They downplayed it, argued the pressure and rip-off opinions were just side issues, internal chatter, no actual entrapment happened, the defendants were willing participants, police pressure was just to get evidence, and a cop's opinion about a rip-off isn't proof it was happening.
They argued it wouldn't even be admissible evidence.
Or at least limited use, maybe for cross-examining Oscar or W. And even then, admitting they suspected a ripoff might just show why they kept pushing Reardon. The Crown felt the trial judge would have told the jury to ignore police suspicions regarding Reardon's actual intent anyway.
So the judgment in June 2002, what was the final decision on the convictions?
All 3 convictions were upheld. The court found no errors in the trial itself. Jury issues the S-165 warning, allowing the S.38 cross-examination of Crombie amounted to a miscarriage of justice requiring the verdicts be overturned. Justice Simpson specifically rejected Reardon's trial-related grounds.
And the running sheets. The non-disclosure issue.
The court, led by Hodgson J.A. on this point, found the non-disclosure did not deny them a fair trial. He concluded the running sheet material could not reasonably be considered to have affected the jury's verdicts.
Why not? It sounds pretty relevant, especially for Reardon.
The court reasoned a jury wouldn't likely acquit just because some police officers speculated about a ripoff early on, especially when weighed against all the direct evidence of Reardon planning the import. They felt Reardon hadn't lost a real chance of acquittal because of this non-disclosure. The proof of guilt was just too overwhelming, independent of those logs.
But they did get some wins on sentencing.
Yes, significant adjustments there. Reardon's head sentence, 17 years, 11 months, stood, but his non-parole period was cut from 14 years down to 12. Hodgson J.A. thought the original 14 years was exceptionally long as a proportion of the head sentence and hadn't given enough weight to rehabilitation prospects.
Michael's got a reduction, too.
A bigger one. His 20-year head sentence and 16-year non-parole were both quashed, reduced to 18 years head sentence, 13 years non-parole. The court felt 20 years was too high, considering his priors, his role compared to Reardon's, and maybe compared to Crombie's sentence.
And Taylor.
His 12-year head sentence stood, but his non-parole was cut from 10 years down to 8. Again, the court felt the original non-parole period was too long, leaving insufficient opportunity for parole.
Okay, so June 2002, conviction stands, sentence is adjusted. Surely that's it.
You'd think so, wouldn't you? Most cases would end there, or head to the high court if there was a further point of law. But Reardon's team wasn't quite done with the Court of Criminal Appeal.
What happened next?
His new legal advisors looked very closely at that June 2002 judgment, and they found what they believed was a gap.
A gap.
They argued the judgment discussed the running sheets mainly in relation to Michael's police pressure argument, but they felt it did not deal with the suggestion, advanced by Mr. Ramage QC for Mr. Reardon, about the sheet's specific relevance to Reardon's ripoff defense. The argument that police suspecting a ripoff directly supported his specific claim of faking it.
They felt that specific point hadn't been addressed.
That was their contention, that the court hadn't explicitly engaged with or dismissed the argument that the logs corroborated Reardon's particular defense theory.
So what did they do? Appeal again?
Not exactly appeal again in the traditional sense. They took a very unusual step. They applied to the same Court of Criminal Appeal panel to reopen the appeal they had just decided. This became R.V. Reardon number 2.
Reopen a decided appeal. Can you even do that?
That was the big question. Let's note the teams for this round. R.V. Reardon, number 2, 2004. Same judges. Hodgson J.A., Simpson J., Bar J. Crown, again led by Mr. Roberts S.C., now with Mr. G. Farmer, instructed by the CDPP. But Reardon had a new team. Mr. H.K. Donji as counsel, instructed by S. O'Connor. A change from Ramage QC.
What was the argument for reopening? Procedural fairness?
Essentially, yes. That the failure to specifically address the rip-off defense corroboration point in the first judgment denied Reardon procedural fairness. He hadn't had his key argument on that evidence properly considered by the appeal court, they claimed.
And the decision. June 2004.
Application dismissed. Firmly. The main reason, lack of jurisdiction.
Meaning the court just didn't have the power to do it.
Exactly. Once an appeal court delivers its final judgment and the orders are perfected, formally recorded, the court becomes functus officio.
Functus officio. Latin.
Means task performed or office discharged. Basically, the court's job on that case is done. It can't just reopen it and have another go, except maybe to fix tiny clerical errors. The judges said if Reardon felt a point was missed, the proper route was to seek leave to appeal to a higher court, the High Court, not come back to them. Justice Simpson explicitly said they lacked jurisdiction.
Did they say anything about the merits, though? If they could have reopened it?
They did. They said even if they did have jurisdiction, they would have refused on the merits anyway. They'd reconsidered the running sheet material and arguments and were still convinced no substantial injustice occurred. Hodgson J.A. repeated his view. Reardon hadn't lost a real chance of acquittal due to the non-disclosure.
Why not? Why wasn't the corroboration point stronger?
Their reasoning remained the same. The police opinions in the logs wouldn't likely have been admissible as proof of Reardon's actual state of mind. At best, usable in cross-examination. And any opinion evidence would probably have been ruled irrelevant by the trial judge, with a direction to the jury to ignore it. Juries follow directions, so realistically, it wouldn't have changed the outcome. The reopening attempt failed on both procedural and substantive grounds.
Wow, what a saga. From the initial plot to multiple appeals. Looking back, what are the big takeaways here? Especially for lawyers, for barristers?
Oh, there are so many lessons packed into this one case. It's a goldmine, really, or maybe a minefield, depending on how you look at it.
First up, dealing with witnesses like Crombie and W, the unreliable ones.
Huge challenge. Accomplices, informants, they come with baggage. Their motives are always suspect. You need extreme caution. And the Crown's use of Section 38 to cross-examine Crombie.
That was clever, wasn't it?
It was skillful and upheld on appeal. It shows barristers, especially prosecutors, have this tool, S38, when your own witness goes sideways, but you have to use it properly, transparently, get the judge's leave.
And ethically, the prosecutor can't just ignore inconsistencies.
Absolutely not. They have a duty of candor. If your witness is unreliable or contradicts themselves, you have to deal with it openly. Using S.38 was seen as fulfilling that duty, even though it looked odd. And for the defense, it can actually open doors, reveals cracks you can exploit further, highlights the need for sharp cross-examination skills.
What about the warnings? The Section 165 warning about Crombie.
Absolutely critical. The trial judge gave a strong one, and the appeal court noted it. Barristers, prosecution, and defense need to be all over these mandatory warnings for unreliable evidence. Accomplices, informants, identification evidence. Make sure the judge gives the right warning, properly formulated.
Because if they don't,
Conviction can be quashed on appeal. Simple as that. Waste to trial, huge costs. It's even seen as an ethical duty for counsel to remind the judge if they forget a required direction. You have to know these rules inside out.
and the duty of disclosure, the running sheets issue.
A massive point. Even though the non-disclosure didn't flip the result here, the principle is fundamental. The Crown must disclose material that could help the defense or undermine the prosecution, even if they think it's weak or just an opinion. Defense needs to be persistent in chasing disclosure.
Then there's the final act, Reardon, number 2, the attempt to reopen. What's the lesson there?
Finality. Know when the fight is over, at least in that particular court. Appellate courts don't revisit perfected judgments. That functus officio principle is strong.
So trying to reopen was a gamble that didn't pay off.
Right. It failed on jurisdiction and merits. The safer course, as the source material suggests, would have been seeking high court review promptly on the specific point they felt was missed in the first appeal. Delaying and trying the reopening route might have actually hurt his chances overall. Practice pointer. Exhaust your direct appeals, then usually you have to move on. Reopening is rarely an option.
And Justice Simpson's comment about ethical candor after judgment.
Yes, that's important too. If you get a judgment and genuinely believe the court missed one of your arguments, you have a duty to tell the court straight away. Don't sit on it and try to use it tactically later to reopen things. Transparency is key throughout the process.
So Operation Opaline, it's more than just a true crime story, isn't it? It's a real deep dive into the machinery of justice.
It really is. Spies, plots, sure, but also a masterclass and a cautionary tale in legal procedure, ethics, advocacy, all the way from the docks to the highest appeal courts.
You see the challenges laid bare. Handling tricky witnesses, ensuring fair warnings, the immense weight of disclosure, knowing the procedural limits when a judgment is truly final. Concrete examples of what barristers face.
Exactly. The responsibilities are huge.
So here's something to think about. If experienced lawyers dealing with a massive case like this can still end up in a situation where a point they think is vital gets potentially overlooked, and then the attempt to fix it hits a procedural wall like functus officio. What does that really tell us?
It tells you about the need for constant vigilance, doesn't it? The absolute mastery of technical rules required to be effective.
Right. How much does winning or losing, or even just getting a fair outcome, depend not only on the facts, but on navigating every single procedural step perfectly, even after the verdict? Something to definitely mull over.
A sobering thought for anyone entering the profession.
Thank you for joining us for this deep dive into Operation Opaline and its enduring lessons from the dock.